So we will continue the discussion about the DMA and in particular on certain obligations relating to data and interoperability. And I mean, beyond going to the a few specific obligation of a few specific provisions of the DMA, I would also like to give you this taxonomy that might help you in navigating through and reading the text of the act, which is not so clear, at least at a first reading. Also, as we were used to, let's say, a few very short provisions in competition law, now with the DMA, I mean, it's really a detailed regulation. We really depart from what we were used to as Article 101 and 102, essentially. So first of all, let's say why having a classification of obligation of the DMA? Well, I mean, it's quite hard to spot all of the obligations. There are 28 actually specific do's and don'ts for gatekeepers, and these are, let's say, of course, set out in the 54 articles of the DMA, but also the recitals, the more than 100 recitals try to help in interpreting the provisions, the actual articles. And as we are competition lawyers and economists, I mean, we love taxonomies of theories of harm. We like structured legal tests. And so in this sense, hopefully having this taxonomy can also help us to reconnect what's in the DMA to what we already know from competition law. And also in this sense, trying to increase legal certainty and uniformity across the EU. To a certain extent, we can also clarify some of the doubts of the DMA, considering its background and general context, ensure consistency, and also evaluate proportionality of this obligation. And so it's always important we have this principle from the treaties, and it's important to consider each obligation on its own. And in the enforcement and in the compliance and in enforcement processes, this classification can also ease the processes of assessing compliance, and in the sense can help gatekeepers, but also the competition and the national competition authorities when enforcing the DMA. So some of the variables of this classification, Marco already mentioned. First of all, let's say the main one, the behavioral, so really those obligations in the famous Article 5, 6, and 7, and all the rest, like the compliance obligations, which are mostly toward the Commission as the main enforcer. Then within the behavioral obligation, we can have self-executing ones, which Marco is skeptical about this distinction, but in theory, let's say Article 5 and all the compliance obligation, I mean, they do not need any clarification from the Commission. The gatekeeper simply has to follow what's in the law and cannot ask for, let's say, a specification decision. On the other side, those obligations in Article 6 and 7, which can be further specified in a regulatory dialogue with the Commission. The domain of the obligation, I mean, we will focus on those addressing sharing of data and interoperability, but other domains of the DMA obligation concern ads transparency, unfair conditions, so something really familiar for us as exploitative abuses under Article 102, we could say, and then compliance. The subjective application of the obligation is also not so simple. It's quite complex. So among the behavioral obligations, some apply to all gatekeepers, which so they have a general application. Other obligations, like for example, the one of Article 5.2 of the data silos, so the one that was mentioning that is at the heart of the of the non-compliance proceedings against Meta is an obligation that only concerns those gatekeepers that exceed the thresholds of the quantitative thresholds of presumption of a gatekeeping status. They exclude all those gatekeepers that do not meet the quantitative thresholds, but on a qualitative assessment for the commission, they are likely to have a gatekeeping positions and in the future, in the foreseeable future, and so for that reason are, despite not qualifying under the quantitative thresholds, they are nevertheless designated as gatekeepers. And in this sense, we can distinguish like normal gatekeepers and incipient gatekeepers. So gatekeepers that are growing and will and for the commission are expected to grow even more. Passing to the objective scope of application of the obligations, some obligations apply to all core platform services, while other obligations just focus on certain selected core platform services. And so really, these selective obligations focus on just certain products and services, while others are for all the core platform services. Marco mentioned the timing aspect, so obligation that started immediately once the DMA entered into force. Other that the most important, the behavioral obligations of Article 5 and 6 start in 6 months after each designation. And finally, Article 7 on interoperability of the messaging apps having a much longer time frame of application. Then we can also consider like whether the obligations are, let's say, just a one-shot need to comply or like a recurrent compliance need. And for example, all the reporting, there are 2 main reports from the gatekeepers, but the one on consumer profiling and the compliance report, these are annual reports. So we expect that every year after the date of the designation, we will have, let's say, updated information from the gatekeepers. And these, I mean, as a suggestion, I mean, for even for national authorities that are dealing with digital platforms, these compliance reports that are published online are very informative. So they can really ease, provide context of the relevant, even of the relevant market of the core platform service concerned. And so this is our quite an useful addition. You don't need to ask for this information, at least the gatekeepers is obliged to provide it and update this information annually. Other obligations have must be complied all the time, so they have a continuous value. For example, on content portability for users, I mean, this is needs to be respected and needs to be complied on a permanent basis. And finally, certain obligation, for example, the obligation to notify the commission of meeting the thresholds, of course, they are not, they do not apply until the situation is triggered. And so just upon the status change. More variables of this classification, as in any sector regulation, we have negative obligations, so don'ts, and positive obligation, do's. Then we can also consider the market failure addressed, and Marco mentioned that the DMA is not a concern about consumer welfare or the more general competitive structure, is really focusing on contestability, and so competition within the same platform and among platforms, but also concerns fairness issues and transparency. So this is, let's say, the goal that the DMA regulation tries to ameliorate and to pursue. The legal relationship, that is something that also Marco stressed, and we can have, let's say, obligations toward all users, both end users and business users, just end users, just business users, or just the commission. And perhaps something interesting to think about this, let's say, intended recipient or beneficiary of the obligation can be, if you think about private enforcement, let's say, those obligations that are towards business users. I mean, these are the most prone to be enforced in courts, no? And so hopefully we will see some degree of private enforcement also under the DMA. And I was hearing from Sonia some interesting recent developments in this sense. Not all obligations, let's say, must be complied by the. I'm talking about the behavioral ones, must be complied by the gatekeepers spontaneously. We will see many of the data-related obligations are just obligations to comply and to fulfill a request of the user, and so there is no need, let's say, to be compliant until a user requests so. Then many obligations either explicitly or implicitly foresee the need to cooperate with other authorities, other sector-specific authorities. We can have, for example, the European Data Protection Board. So those obligations are relating to personal data. I mean, it's important to have, let's say, the view of the data protection authorities. Also, the obligation that Marco was mentioning of informing about foreseen concentrations. Here, of course, I mean, it's explicit the need to cooperate for the commission with the national authorities that might refer the case under Article 22, as recently interpreted by the Court of Justice in Illumina. In other obligations, let's say this need for cooperation is implicit. So we can expect just to have, let's say, an informal cooperation, not just not explicitly mandated by the DMA. And finally, this is the, let's say, last variable of this classification. We can think of the legal background of the intended obligation, and we will see, for example, I mean, Article 5.2 on personal data silos. I mean, here, let's say, there is a lot of background in the GDPR, but otherwise, the Article 7, so the interoperability of the messaging apps. Here, there is a lot of telecom regulation in the background. And yeah, here you have a table with, let's say, just focusing on the behavioral obligations. And I mean, in our case, we will focus on those highlighted in orange and green. The slides have more obligation that we will discuss in the interest of time, but I mean, we will you can have a look. I mean, and let's say there is a more or less a discussion in the slide of each of these obligations. So to hear from you, so now we have the DMA, and I would like to know who are, in your opinion, the main beneficiaries of this new law. And a first option could be existing businesses and businesses that depend on the gatekeepers to offer their services in the EU. Otherwise, these can be new businesses, so innovators and startups, and which, thanks to the DMA, they do not bear unfair terms and conditions, so that limit their innovation potential. A third option could be digital incumbents, so more or less the competitors of the DMA, and with their like very plentiful resources can make the most out of the DMA. Finally, I mean, consumers as all we can benefit from more online competition in price, quality, and hopefully innovation, or I'm not sure. So I'm just to like my opinion would be that the digital incumbents, so the competitors of the gatekeepers, can really use this law at its best. But perhaps you have a different view. So does anybody think that like this is just beneficial for any business or for innovators, new businesses entering the market, or consumers? Are we seeing more choice online after the DMA? I mean, all of us experienced, at least with the phone, like, oh, do you want to keep using me as the default browser, or do you want me to be the default GPS navigation maps? Or so something we have seen, and I don't know if you think this is let's say enough from the DMA, or perhaps we would like to see more choice. Or I mean, of course, it's there's no correct answer to this to this question, and we will see over time. So starting with the data related obligations, a lot of the terminology in the DMA relating to data comes from the privacy area. And of course, when we talk about data, we mean both personal and non-personal data. And so the distinction is also relevant under the DMA. When we talk about data portability, this is something like it's a right that one to receive one's own personal data provided to a data controller. And this is, let's say, already defined under Article 20 of the GDPR, and the DMA employs, let's say, the same definitions. Data sharing, the provision of data by a data subject or data holder to a data user. Again, this is something that is defined not in the DMA, but you have to go and read another recent regulation, which is the Data Governance Act. Still, I mean, more definitions, and if you work with the DMA, you will have ever more to be up to date with the data protection laws and interpretation by the authorities. Why, let's say, the DMA addresses and improves access to data and data sharing by the gatekeepers? I mean, data has those features of public goods, so it's non-rivalrous and non-consumable. So in this sense, different parties can use the same data even at the same time without depleting its usefulness. It's also an intangible and non-excludable asset. And so once the data is shared, the data holder loses the control over the data. And so there is an incentive not to share the data in the first place. And also we can see economies of scale and scope regarding data collection. So the larger the amount of data that is collected, the larger the value of the data set. And in this sense, a data set has a higher value. Like it's than just the sum of the individual information. There is also a very high upfront cost of setting up a data infrastructure regarding like the sourcing of the data, the architecture of the data, the governance and the analytics of the data. But once this infrastructure is set up, there is a very, let's say, low marginal cost of collecting more data. No? And so in this sense, for all the platforms, most of the data that we provide, most of the personal data is just a byproduct of the service provided by the platform. It's just something that we provide while using the service. And because of also information asymmetries, so we don't really know, let's say, the content of the data set until we look what's inside the data set. Because of a transaction cost regarding how to agree on a contract regarding data sharing, and also due to the market power that companies accumulate through the gathering of data. I mean, we can reach these market failures, and of course, to a certain extent, the data can be as any other asset indispensable to compete. We can question whether like it's indispensable, but perhaps replicable. No, it's like differently from, I don't know, a harbor or an airport. I mean, somehow, I mean, it's true that it's costly to put together the data infrastructure, but perhaps it can be replicated more easily than a port or an intellectual property right. Then also big data advantages. So the more data that a company has, the more that it can make use of this data and diversified, let's say, especially if the data is diversified. And of course, what we already know, like the indirect network effects with feedback loops. So the more data is gathered, the better the algorithms become, the better the service become, and the more users are incentivized to join the service and provide more data, and this in a feedback loop. And I'm just, I mean, companies, a myriads of apps, let's say, know a lot about us. I mean, it's impressive what they know about, like, our face, our voice, about the environment where we are, the location where we are. I mean, there are, let's say, data protection consultancies that put together these tables. I mean, it's I don't know how accurate or reliable they are, but this is just to give the impression of the variety and the amount of data that the company, the digital companies have about us. So now coming to the obligations, the data-related obligations, we can divide these obligations in two groups. Those that limit gatekeepers' own use of the data that they have. And on the other side, those proactive obligations that incentivize and allow the sharing of the data from the gatekeepers to the users. And I mean, we will focus on Article 5.2 on the personal data silos without a specific concept by the user. Also because here there is this non-compliance proceeding against Meta that Marco mentioned before. But I mean, you will have, let's say, the slides also for the other obligations. So Article 5.2, personal data silos. So it's a prohibition, and it's a prohibition that concerns only the gatekeepers that exceed the quantitative threshold. So incipient gatekeepers are excluded from this prohibition. And under Article 5.2, without end user specific consent, gatekeepers cannot process personal data from third-party services for their own online ad services, cannot combine personal data from different first and third-party services. And this is really what's at the basis of the German Facebook case. And also, they cannot cross-use personal data from a core platform service in another of their own services, whether or not this is a CPS too. And the DMA in its recitals also provides some explicit compliance requirements. And for example, I mean, to comply with this obligation not to use and to keep personal data separated without the user consent, at the same time, if this consent is not given, the gatekeepers must provide a less personalized core platform service to users that, I mean, yeah, that they really refuse consent to give the consent. And this is called the fallback option. So the fact of not giving consent shouldn't preclude the user to be on the platform. Also, the user interface to provide or modify this consent should be user-friendly, and there shouldn't be dark patterns. And the choice should be prompted at least, at maximum once per year. Also, there can be exceptions to this prohibition to cross-use personal data, just in case of the need to comply for the gatekeepers with a legal obligation, a vital interest, or a public interest. I mean, this is something that we already knew under the GDPR. And at the same time, there are a lot of uncertainties and critiques to this prohibition. And first of all, this is a critique that is quite well known in the data protection circles. I mean, consent is really not the best legal basis for data processing. No, it's I mean, we are quite willing to give consent just to skip, let's say, just to accept cookies, for example, or just to be online as quick as possible. So. And this is known, let's say, for example, the consent fatigue that perhaps Paulina was referring to, but also information asymmetries on the value of our data for the platform that collects it. But also, there can be problems really in abusing the right and just asking like a consent in an abusive way. And perhaps here, like the DMA could have been better if it anchored the legal basis for the data processing to the necessity to perform a contract. So if it's really necessary for providing a social media to use the data from the personal data from the messaging service, I mean, if this is really necessary, there is no need for the consent, and the platform can combine these two types of data from different services. But if it's not necessary, why doing so? And just because the user doesn't really know and just consent without really having a clear picture of what is what him or her consent is referring to. And also, especially for the prohibition, like just concerning online ad services. So let's say online advertising services are not really a single data processing purpose, and like the consent should be detailed and specified for purpose specific, should be purpose specific, and so should be really much more granular and given for specific ads, online ad services, not just in general. No, it's we know that also in the abuse of dominance cases where online ads services are at issue, both in Europe and in the US. I mean, the authority can be quite specific in defining the relevant market for the online ad product in question. And so in this sense, perhaps the consent should be given for the specific online ad service. Yeah, and in general, I mean, this is, let's say, the last critique. It's contestability, because this is this obligation should also promote contestability from smaller competitors that do not have access to this variety and vast, a large user base. I mean, contestability from these smaller companies should not depend just on our end user consent. I mean, we are not really informed. We don't know. We ignore, let's say, the full picture, and so perhaps it would have been better to use another legal basis, such as the necessity to perform a contract. Again, I mean, just as general knowledge, I mean, privacy policies, we know they are not so read in the first place, and not even if you try to read them, they are not so easy to be read. No, and this is just to highlight that, yeah, consent, user consent, it's something that is not really working to protect privacy rights. And before moving to, let's say, the Meta case relevant under Article 5.2, I mean, I wanted to know if you are ready to pay between 5 and 10 euros per month to have like a digital service, like a social media or messaging app without ads, without advertisement. Is there anybody that, yes, always would like to pay, and because the personal data is much more important, and doesn't care to have the digital service free to use, it's privacy is more important. Anybody? Sorry. Okay, so you wouldn't pay. No. So instead, perhaps you value different services differently, and so perhaps you would be willing to pay for some, but not for all of them. Also, because if we start paying for for one core platform service after the other, I mean, these 5-10 euros can add up to a quite large sum. So, does anybody perhaps already pays for the paid version of Instagram or Facebook that is already there? You? Yeah. So no, well, also no. This one, so most of okay, but for Paulina, for like services that are regulated under the DMA or other services, or if you think about, I don't know, I mean the browser or the messaging app, the marketplace, there might be an interest to have, let's say, personalized services and personalized ads. So perhaps this is also why, I mean, most of the users have not switched to the paid version. And this is also why the conduct, the compliance conduct that Meta has put in place for its social media, for Facebook and Instagram, is being under scrutiny by the Commission. So after, let's say, the compliance report that detailed set out in detail the way that Meta was was complying with article among the others, Article 5.2 for its core platform services. I mean, it explained this pay your consent binary model, and in this sense, I mean, the choice that Facebook currently gives for both Facebook and Instagram is either to pay a new premium version without online ads, like really without advertisement. And this is actually cost about 10 euros per month. And if, I mean, this is let's say CPS specific, so 10 euros for example, for Facebook. And if you add another account of Instagram, these are other 6 euros. And interestingly enough, the price is different if you buy if you subscribe to the premium version online from the browser, let's say, or if you subscribe using the app or the app store of Apple or Google. And so this is relevant for other, let's say, obligations under the DMA. But so, I mean, it costs more to subscribe within the Facebook app that you have on your phone. And so this is, let's say, the addition that the Meta introduced to comply with Article 5.2. The other option that stays there is the old option, the one of the old version without personalized ads, but with advertisement. But let's say that for the Commission, this binary model of paying or consenting really is not really determined consent, and is also not enough to promote contestability, because Meta still accumulates personal data, and this still continues to grow the entry barriers for smaller competitors. And so what perhaps the Commission has in mind is a third option among in addition to the other two, so a new, less personalized, but equivalent version of Facebook and Instagram with non-personalized ads. And so in this sense, the DMA in the recital specifies that the refusal of consent by the users can justify differences or degraded quality of service compared to the non-personalized, to the personalized version, sorry. And so, I mean, of course, there can be quality degradation just because there is no consent, but I mean, otherwise, if the reason for the quality degradation is something else other than consent, I mean, this is perhaps doubtful compliance with Article 5.2. But we will see. I mean, tomorrow during the conference, I mean, this case will be really delve into more details. Other data-related obligations. Article 6.2 concerns, let's say, business data firewalls. So gatekeepers, excluding incipient ones, must not leverage not publicly available data generated or provided by business users or their customers to compete against these business users. And I mean, think about marketplaces, hybrid marketplaces, where the marketplace both offers, let's say, third-party products and knows about the data of these third-party products, and also sells his own unlabeled goods. I mean, like the data about the third-party products should not be used to compete against these third-party sellers. And there are again explicit compliance requirements, such for example, the inclusion of like the data that is not publicly available includes aggregated and non-aggregated data inferred or collected through the activity of the business users or the customers, and this can relate to click, search, view, or voice data, and this is quite explicitly stated in the DMA. For example, the data that is covered by this prohibition might be provided by business users for online ad services. So it can be the data that the business user even gives to use the advertisement services of the gatekeeper. And there is an exception to this prohibition, and it concerns the use of aggregated data for providing complementary services to cloud computing. And again, the law is not free from uncertainties and critiques. Like we know, I mean, also from merger remedies, that firewall provisions are not perfect, and so they can be, let's say, they're quite costly to implement. So to cost of put together hardware and software firewalls, also the difficulty of monitoring compliance. I mean, how do you know that in the end the information is not leaked through and used? And there might be also borderline data uses that might or might not be under the scope of the prohibition. And perhaps, I mean, it's this is just a question, is restricting access to the data to just identify the employees enough? I mean, this is something that we will see and is emerging as let's say, as we read and we receive the compliance reports from the gatekeepers. I mean, these are issues that are being addressed in these reports and in the subsequent non-compliance investigations. The last data-related obligation that I want to mention is Article 6.9 concerning end users data portability. So this is not a prohibition. This is let's say, a positive obligation, and in this sense, it provides for gatekeepers that must guarantee to end users and their delegated third parties the effective and free portability of data provided or generated by the end user. And perhaps, I mean, of course, compliance is just upon request. There is no portability until the end users ask for it. And a quite relevant critique is that why the DMA had to specify that also delegated third parties can exercise the right. I mean, this is something that in any legal system, I mean, you can delegate somebody else to exercise your right. And so this is might be, you know, also a limitation in favor of gatekeepers that might ask specific, I don't know, power of attorney or specific forms to refuse this data portability. And so perhaps it would have been better just to say end users, and then if the end users wants to use another competing business digital service, I mean, doesn't need to have any formality. I mean, so this is, let's say, just the DMA went beyond perhaps what was necessary. Okay, any question, any experience with data sharing also under national competition law? Or, I mean, this is something that comes as a novelty for competition authorities. I mean, it's not competition law, but we now have the Data Act. So this is another digital regulation that tries to create and promote a market for industrial data relating to IoT products. So trying to spur the sharing of this data. And I think, I mean, there will be, let's say, if up to now the data portability and data sharing has been limited, and really end users didn't make much use of data portability, perhaps also under this new framework of the Data Act, we can see more the emergence of a market for data with more transactions and data being shared, not replicated, and bigger data sets also because of this sharing. So let's say this is something that goes beyond pure competition policy. No, it's really something broader. Okay, if there are no questions, we move to the interoperability obligations. And in the digital sector, we have many examples of digital interoperability already. Think of the emails. We use different providers of emailing services. We have different clients to manage our emails, and like they all work fine together. I mean, we don't need to care what provider our recipient has. I mean, we just send the email and the email arrives. Also, it's possible. I'm not a proficient user of social media, but I remember it's possible also to post the same, to cross-post the same statement, the same picture on different services. I mean, this is something that is it's already there. And even like in non-suspect times, so before the DMA discussion, actually. Meta, I mean, I don't know if it was already Meta back then, but Facebook in 2019 even announced spontaneously that it would have integrated its messaging apps and made it possible for the different apps to send messages among each other. Then, which is relevant also for the ongoing cases, non-compliance proceedings against Apple, the fourth interoperability example of third-party app stores on Android. I mean, on Android, you can already have not just the Google Play Store, but also other stores from other providers. And so, I mean, it's interoperability is not something that doesn't exist online. And so even the resistance from the gatekeepers, I mean, has to be put in context because it can be done, let's say. And we have, of course, interoperability for engineers is something, and I mean, you have there a definition from the Society of Engineers, IEEE, but they mean for interoperability, the ability to transfer and render useful data and other information across systems through interfaces, essentially. And the DMA also provides a legal definition of interoperability, and it says that it's the ability to exchange information, and this is, let's say, technical interoperability, and mutually use the information which has been exchanged. So, like this exchange must make sense for the parties involved in the exchange, and this is the so-called semantic interoperability, and this exchange and mutual use of information happens through interfaces or other solutions, so that all elements of hardware or software work with other hardware and software and with users in all the ways in which they are intended to function. So the DMA really endorses a definition of interoperability that goes toward full interoperability rather than partial interoperability. The usual means of ensuring interoperability, technical standards, for example, those behind the emails, those are technical standards, internet protocols, but also, for example, technical standards are the one like Wi-Fi or 5G to connect to the network. Then there can be another solution, which is like open application programming interfaces, APIs, and APIs are more or less in the way I understand them as sockets, restricted sockets to connect systems, applications, or components. So really, you might need, let's say, the plug for each specific system, but at least there is a socket where you can plug in. Then another way of interoperability, of ensuring interoperability, is the compilation. So reverse engineering to achieve interoperability, and this is quite common in software. And actually, under the IP laws, and the patent laws in particular, and copyright laws, there is actually an exception to ensure that this way of ensuring interoperability is not limited by exclusive rights. Another important aspect of digital interoperability is the distinction between horizontal and vertical interoperability. And think of horizontal interoperability as interoperability between competing products. So, for example, I don't know, WhatsApp and Viber. So these are two competing products. And if these are interoperable, this becomes an horizontal interoperability. And this enables positive direct network effects among the same group of users. On the other side, you have vertical interoperability. And this is interoperability between complementary products. So, for example, an operating system and the apps that go on that operating system. And vertical interoperability supports indirect network effects. So the positive, the benefits, so the more users of an interoperable product they think of an operating system, the more the value of the complementary interoperable products such as apps that go on that operating system. And in the DMA, you have obligation that both concern horizontal interoperability and vertical interoperability. As most of you come from competition authorities, I mean, we can say that interoperability is already there in several sector regulations in Europe, and this is just because when we have a sector regulation, it's because we have a natural monopoly, usually, a market that exhibits natural monopoly features. And so it's a usual obligation in many of the sector regulation. It's also a usual remedy in many competition law instances. No, we have under Article 101, Article 102, and even under the merger regulation, I mean, interoperability obligations are used to remedy the market failure at issue. Of course, I mean, it's not interoperability is always good or always bad. There are several pros and cons for interoperability. And I'd say the main pros and cons is like the more or less also the debate that is behind, let's say, mandatory licensing of intellectual property rights. Now, you know, like once you obliged to be interoperable, you diminish, let's say, the incentives to invest and innovate in your product at issue that the law or the authority wants to open up for the broader competition. And so in this sense, I mean, perhaps the argument that mandating interoperability somehow diminishes the appropriability of research and development investment is the strongest one. And in general, because of the several pros and cons that economists can bring forward in any individual case, the policy debate about interoperability is not on full interoperability or no interoperability, but should be on the just optimal degree of interoperability that balances somehow the concerns like the pros and cons. Coming to the DMA, there are several obligations that deal with interoperability. And here again, we can have a distinction between those obligations that try to spur proactively interoperability and other obligations that are more, let's say, on the negative side that try to prohibit leveraging of market power of the gatekeeping status from one service to another. And interoperability obligations are under like Article 5, so those that are self-executing, they are under Article 6, and there is even like just Article 7, as we already mentioned, just concerns interoperability among messaging apps. Before delving into the details of some of these interoperability obligations, I wanted to ask you this question. So I don't know how many of you use iPhones or how many of you are users of Android phones, but perhaps it's interesting to know from both types of users whether you think that Apple iMessage should be interoperable with other messaging apps such as WhatsApp, Viber, Signal, or the like. So does anybody would like to keep iMessage just for Apple users? Does anybody says no, shouldn't be interoperable? I mean, everybody would like to see it interoperable. Like, unfortunately, I mean, I'm sorry, but the commission decided that iMessage is not a core platform service that applies that is under the DMA. So for Apple, there is no need to comply with Article 7. It's excluded from the application of the DMA. So we will not see iMessage like being used to talk with friends and users on WhatsApp. So it would be kept as just an Apple product. And perhaps, I mean, it's true that the users of Apple value and the premium quality features of Apple and the enhanced privacy protection that Apple apparently has put in place in its closed ecosystem. Okay, so we are going to see a few interoperability obligations that are at issue in the, for example, in the proceedings, DMA proceedings against Apple. So the first one is the obligation of Article 6.3, which is the obligation to ensure easy uninstall and an easy change of default settings. And this is just for gatekeepers, excluding incipient ones. And the obligation imposes the enabling of end users to both uninstall apps from the operating system and also change the default settings on certain CPS. So the CPS affected by this obligation are operating systems, virtual assistants, and web browsers. And there are some explicit compliance requirements, but of course also critiques. So another interoperability obligation is the one to ensure, let's say, so-called direct downloading and subloading from outside the operating system. So again, gatekeepers must enable the installation and effective use of third-party apps and app stores on their own operating system. So this obligation focuses on operating system as the only CPS. I go quickly also because I want to go on the Apple case. So finally, Article 6.7, so software and hardware interoperability. So gatekeepers must guarantee access and interoperability with the same hardware and software feature of operating system and virtual assistants that they use also that the gatekeeper directly uses also to compete in software and hardware. And also this obligation includes the guarantee of interoperability with the operating system features for services complementary and supportive of the CPSs. And so with this obligation, after the Apple published the compliance report, let's say the commission started to think about it. And first under Article 6.3, so the obligation to ensure the uninstall, easy uninstall and change of default settings. So it opened the first non-compliance proceedings regarding the way that Apple ensures on its own iOS, so the operating system of the iPhone, the possibility to uninstall and change the settings. And in particular, the Commission is concerned because Apple apps such as Safari, also the way the settings are designed, the interface for the settings, Apple App Store, phone, like the app to call, messages, camera and photos. These are all apps that can be removed. So you can like delete them from the screen, but they are not actually uninstalled from the phone. And so the Commission is investigating whether this solution that Apple has put in place to comply with Article 6.3 is actually in compliance or not. So we will see. I mean, you have there the expected date of the decision. For these non-compliance proceedings, the time limit is 1 year. So if the decision to open the proceedings is from 25 March this year, I mean, we will have the decision by 25 March next year. Then in June, another non-compliance proceeding for Apple, the way the Apple operating system ensures, let's say, the possibility to download apps from directly from the app developers' website or through alternative app stores. And here, Apple has put in place, let's say, I mean, quite detailed and quite cumbersome requirements from a legal perspective to allow side loading, and even imposes a fee, a so-called Apple calls the core technology fee for the App Store for the apps that want to be downloaded outside the App Store. So there is, let's say, something like a charge that Apple imposes on the apps once they reach a certain number of downloads, like more than 1 million downloads. I mean, this fee starts to apply, and Apple, let's say, justifies this new fee on the apps that are downloaded outside his own app store, just because it needs to implement cybersecurity of its own operating system to safeguard, let's say, put in place technology infrastructure to allow this possibility of side loading. But at the same time, let's say the Commission is concerned that the way that Apple ensures side loading is really can be quite restricting. Like, Apple really has quite a vetting process that is quite cumbersome, and also the choice steps and the screens that users need to go through to actually enable and install an alternative app stores. I have not done it, I mean, but because so far the apps that are downloadable from the few alternative app stores are very few, are just like some video games that I'm not really interested into, so I haven't tried. But apparently, if you really want to download an alternative app store, you have to go into the settings and change many features, and it's not so easy. Finally, like a different type of proceeding opened a few weeks ago. These are like not non-compliance proceedings, these are specification proceedings under Article 8.2, and these are specification proceedings under the obligation of Article 6.7 to ensure hardware and software interoperability. And these are concerning both iOS, so the operating system of the iPhone, and iPad OS. And even like before the DMA, there was not such a distinction between iOS and iPad OS. iPad has the same operating system of the iPhone, but perhaps to also try and exploit the differences in the DMA. Also, Apple distinguished the two operating systems somehow strategically, one might think. And so under the specification proceedings, they are not non-compliance proceedings. So there is the scope for the Commission to engage with Apple in a regulatory dialogue and specify how to comply with this interoperability obligation. But the concern is that the connectivity features of iOS and certain functionalities of iOS, like such as notifications, the pairing of devices, also the data transfer, high volume data transfer among devices, used by connected devices in competition with Apple devices. So think of other like non-Apple smartwatches, headphones different from what's the name of the Apple iPods? No, iPods. So those products that compete with the Apple products do not really have access to the same connectivity features. So if you are familiar with the AirPods, you just open the box of the AirPods and immediately appears, let's say, the connection, and apparently this is not so with the competition. And so also, let's say, once a device maker asks Apple to be interoperable, there is really a very long and not so transparent process of vetting that Apple has in place, which we don't know how long it lasts, like to become interoperable, to get the green light from Apple engineers to start being really interoperable with Apple iOS and iPadOS. And so, I mean, really, just on the not just on the technical features of the interoperability, but even on the mechanism put in place to ensure this for the process to ensure this interoperability. Finally, last obligation I will mention, Article 7, so the interoperability among messaging apps, number-independent communication services, NICs, but messaging apps is, I think it's much easier to grasp. And this is the obligation is interestingly, let's say, a free, like obligation to provide effective interoperability free of charge, so without charging a fee, as instead Apple is doing for side loading, with the basic functionalities list of the messaging apps to actual and potential requesting competitors. And the timeline for complying with this obligation is a bit like, because the Commission realizes that it's might be difficult to interoperate different services. It gives more time for more complex activities. So the first interoperability will concern just messaging and content sharing, I guess, like sharing a picture. Then it will be like this is, sorry, one-to-one messaging and content sharing. So between two end users. And then there will be also interoperability of messaging and content sharing between an end user and a group of users. So also groups might become interoperable. And then the last step will be voice and calls interoperability. So calling or video calling from WhatsApp to Signal or the like. Again, there are some specifications regarding the degree of interoperability needed and uncertainties. But here, there is an ongoing case. It's a decision. I mean, it's a decision that concern mostly like NICs, messaging apps covered by the DMA are just those of Apple, sorry, of Meta so far. So we will see, let's say, this interoperability just with Meta's apps, so WhatsApp, Instagram, and Messenger, Facebook Messenger. And so not for WhatsApp, but for Messenger, Meta obtained an extension, a 6 months extension to ensure compliance with Article 7. First of all, I mean, let's say Meta tried to argue that Messenger was not the designation of a messenger as a CPS was disputed, and so it had less time to comply with the obligation because he felt there shouldn't be a CPS, so he disputed this designation. But I mean, in this decision granting the extension, the Commission didn't buy this argument. I mean, you knew from the beginning, and you tried to dispute the designation, but you knew from the beginning that we felt that Messenger was actually a CPS. But let's say for other reasons that were put forward by the gatekeeper, I mean, the Commission agreed to give this extension. But now, I mean, this extension was granted on 25 March, and so the 6 months ended in September, I think. And so now Messenger can become interoperable upon request of competitors. And so you can go on Meta's website and find a page on interoperability, and there are the terms, like the terms and conditions that has been also reviewed by BEREC, let's say the telecom regulator at the EU level, the network of telecom regulators at the EU level. And so there is, let's say, the draft contract provided online, and all the steps that companies willing to request interoperability must go through to finally be able to send a message to users on Messenger or WhatsApp. In the interest of time, let's conclude. So we have seen also through, like, during Marco Botta's lecture, I mean, the DMA brings substantial legal and policy innovations, but its effective implementation must build upon the background of competition policy and the economic context we all live in. We have classified the DMA obligation according to several characteristics, and the main division that you should have in mind is between the behavioral obligation of Article 5, 6, and 7 toward users, both end users and business users, and the compliance obligations toward the regulator. Then we have seen a few data-related obligations, and these usually aim to overcome the gatekeepers' big data advantages, and they do so through limitation on the gatekeepers' own use of data, and also positive obligations to share the data with third parties. Then turning to DMA interoperability obligation, these promote contestability. And they do so through leveraging prohibitions, as we are quite familiar with under abuse of dominance prohibition, and also proactive interoperability obligation. And each obligation has uncertainties and drawbacks, and we expect, I mean, clarification, first of all, I mean, in the compliance reports, but also from the Commission. And under Article 5, I mean, the only way to give clarification is through non-compliance decisions, while we are already seeing that under Article 6 and 7, there is this possibility of regulatory dialogue and a specification decision under Article 8.2. You have some references, and thank you very much for the attention.